Hello, and welcome to Legal Queries, queer legal questions, clear legal answers. Today, we're talking with Rachel Sabo Friedmann of the Friedmann Firm, and we're calling it Working Hard for the Money, Business and Employment Law here in the state of Ohio. Thanks for listening. Content provided on this podcast is for general informational purposes only. The views and opinions expressed by Attorney Hannah Botkin-Doty and her guests are not a substitute for specific legal advice tailored to your particular situation. If you have legal questions or concerns regarding your individual case, please consult with a qualified legal professional in your area. Hi there, and welcome back. I am Attorney Hannah Botkin-Doty, and you're listening to Legal Queries, queer legal questions, clear legal answers. I'm joined today by Rachel Sabo Friedmann, and we're talking about business, working hard for the money, employment questions here in Ohio. Rachel, thank you so much for being here.
Sure.
Can you introduce yourself and your firm?
Yeah. So I'm Rachel Sabo Friedmann. I am a plaintiff's employment attorney, and I own a firm with my husband, Pete Friedmann, called the Friedmann Firm. And we do mostly plaintiff's employment litigation. And what that means is that we just represent people in claims against their employer. And I can talk a little bit more about what types of cases that we handle, but we are a people-only firm, and our niche is employment law.
Okay. So people only meaning you don't represent like corporations or employers, right?
Correct. Yeah. I mean, we have done some consulting for small businesses and startups.
Like here's not how to not mess up.
Pretty much. Yeah. And we advise them on the law, counsel them through different situations that are typically unique to their business.
Okay.
But we don't defend employers in lawsuits against people.
And why is that? What's your little dignity, morality behind that?
I think we have always been plaintiffs' lawyers, so I don't really know anything different. When I was in law school, I clerked for a couple plaintiffs' firms that didn't do employment, but that represented people in personal injury and med mal cases, and I just really liked it. I like the idea of representing the person rather than the entity. I think most of the time it's very difficult for individuals to navigate the legal system.
Mm-hmm.
Which
is why we're here,
Yeah.
giving you these insights.
Yeah, and it's an uphill battle for a person filing a claim against a company. So we've just always really wanted to do that, and we've been very lucky to be able to build our practice to be even larger than just Pete and I.
Yeah.
To help more people, and yeah, it's been great.
And how long have you been in practice, Rachel?
Since 2012.
Ooh, more than a decade.
Yeah.
Doing the good
so
work.
Weird.
Yeah.
Yeah, that makes me feel old.
A little. I mean,
yeah, a little.
Experience, let's say.
Seasoned.
Like a cast iron pan.
Exactly.
So the majority of the people listening today are part of the LGBTQIA+ community.
Mm-hmm.
Can you talk a little bit in your experience how you've seen the law change or the law applied as it intersects with our community?
Yeah. So, I mean, I think the biggest thing to be aware of is prior to the Bostock decision, there was no protection.
So for people that don't know what the Bostock decision is.
Yeah, so that was a case decided by the Supreme Court of the United States that essentially gave members of the LGBTQ community protection under the law against discrimination.
Okay.
So.
And which law is that?
Title VII.
Title VII.
Yeah. So Title VII is a federal law that has existed. Well, it's Title VII of the Civil Rights Act of 1964. So it has existed since 1964.
Right.
But prior to 2020 and that decision, it only protected against discrimination based on other types of protected classes. So,
race, sex.
Yeah.
What else?
National origin, pregnancy, disability.
Okay.
Gender.
Okay.
So, yes. So that law has been in effect since then. But in 2020, it changed to protect individuals in the LGBTQ community. So
by defining them or their particular situation under sex, is that right? In this case, what we would refer to as gender, but did it add them as like a whole new section, or did it just focus them or like re-describe what sex was?
So it just, yes and no. I mean, it just basically added LGBTQ status as a protected class under Title VII, meaning that as an employer, you cannot discriminate against somebody based on that status, right?
Right.
And so prior to, it brings up like an interesting point because
Thank you.
prior to that, we would have, so prior to this decision, right, prior to that protection being in place, we would have to get very creative with our arguments. And there were claims that we could bring under what was called like a gender stereotyping theory. So there was some case law related to that, but not a lot. So prior to Bostock, we would have to essentially make the argument that employers were discriminating based on gender stereotypes.
Okay.
Because LGBTQ status was not protected.
Right.
Right. So, like, to give you an example.
Yes, please.
I don't remember the name of the case, but there was a woman who.
Confidentiality, anyway.
Yeah. There was a woman who worked at, let's say, maybe Price Waterhouse. Okay. And she alleged that she was being discriminated against because she didn't fall into, like, this typical female bucket, right? Like,
love a bucket.
Yeah, so basically she'd wear a suit, not a dress.
Oh,
she had exactly right. No. Like, so she had shorter hair, and there were comments about, her not falling into this like typical idea of femininity, whatever that looks like.
But let me ask, did they couch it under like professional look or client experience or like some other BS?
Yeah, okay, something like that. But you could just kind of tell based on the allegations that she made that it was very obvious that the discrimination and the animus was coming from the fact that, she wasn't in a dress, like wearing lipstick, that type of thing. Right? So the argument was this gender stereotyping argument. And that was a really important case because it advanced this idea of the fact that you can make these arguments under a gender stereotyping type claim, but you're really achieving the same thing because the idea was like they really are discriminating against her based on her status,
right?
Which is, her appearance was indicative of that. Does that make sense?
It does.
So those were the arguments that we used to have to make, which we would do. I mean, it's very hard to try to make arguments based on a protection that doesn't exist.
Yeah, that's the lawyering part of it.
Yeah,
where you have to present these factors as opposed to just having a clear line law saying that's wrong.
Yeah, exactly. And just, you get a case, we would get a case in the door where we'd look at it and we'd say, but this is not, this is not right. This is not okay. Like, how can we help this person? And prior to that protection existing, you just have to try to get creative. Even if it was a case of like trying to make an argument for the first time, it's rough because it's unlikely that you're going to win something like that. But sometimes you just do it based on principle because of what something is happening to somebody. It's like, okay, well, I mean, yeah, maybe the law doesn't technically protect against this, but is there like a creative way we can make an argument? And the gender stereotyping cases really helped with that.
Totally. So, and I really like kind of how all minorities are grouped together in one common goal, which is to overcome the expectations of the majority of us to be one thing that they expect us and are comfortable with us being. So by raising one side up, for example, women, and having that included in 1964, which is not that long ago in legal terms, it also elevates the LGBT community. So that's really great. And I totally relate because in family law prior to Obergefell in 2015 making marriage equal, we had to like you said, get creative and like cobble together rights with like powers of attorney or shared custody that people would just get based on their marriage or based on parentage.
Yeah.
And so to have the Supreme Court in Bostock or in Obergefell make a clear line rule saying, no, you are protected. No, you do belong and you do have access to these civil rights. I think that is just so helpful for us because A, not that we're turning clients away, but we can offer them better outcomes. And B,
absolutely.
They're not spending their time, energy, stress, finances, because these people theoretically are lost their job or in threat of losing their job. And then to go out and have to hire an attorney to do what is right without knowing if the outcome will be successful based on the interpretation of the judge is so stressful. and to then have these protections, that's great. So,
Yeah.
anything else that you can think of if you're like in a situation where you're an LGBTQ plus person who's in a situation where they're like, is this harassment? Do I have a claim? What should I do? What are some of your thoughts?
So first of all, I think the most common things that we see are really comments like that,
Mm-hmm.
you know, related to all sorts of stuff,
Sure.
like somebody's marriage, you know, whether they're married, whether they have a partner. People are very interested and oftentimes inappropriate about that.
At work.
For sure.
You're like, this is an ice cream shop. Get me the chocolate chip. Yes, I'm married. Go away.
Yeah, sure. Right. Like, I would say, yeah, I mean, crappy comments, for lack of a better way to describe it.
A legal term? Your Honor, this was a crappy comment.
Legal term?
Yes.
Yeah, discriminatory comments, very common. You know, the other big one, and I haven't seen this, thank God, in a while, but just issues when people are transitioning or having like a gender reassignment surgery.
Mm-hmm.
That's a big one that we've seen, you know, multiple times.
Like how?
Oh, God, just, you know, because I think you can take, well, first of all, if your employer is large enough for you to qualify for FMLA,
sure,
and you have a surgery,
the
you can
Family
take
Medical, Federal Medical.
Family Medical Leave Act, yeah.
Okay, yeah.
So I would say just giving people a hard time when they want to take time off for a surgery like that.
Yes.
Comments related to a surgery, I mean, just, you know, just hatred, I guess, and vitriol. That is one of the most common things that we see with regard to gender reassignment surgeries and procedures. Or, you know, even the lead up to that, you know, where you're going through like the hormonal anything that's part of that.
Yeah.
If the employer knows about that, you know, we've seen a lot of like negative comments related to that.
And is that, you know, the vitriol, as you said, those crappy comments in and of itself, are those actionable? Or is that sort of something where you're like, hey, keep track because something bad is coming?
Yeah, so it depends.
The lawyer answer, folks. If you're waiting on your bingo card, it depends.
Yeah, so Ohio's laws are very employer friendly, okay? Which means, like, as plaintiff's lawyers and as a plaintiff, a person filing suit against an employer, it just makes it hard for you. You have an uphill battle. You're the party with the burden of proof, which just means that, you know, you have the burden of showing that something illegal is happening.
So obviously a criminal trial is beyond a reasonable doubt, which is a very high thing.
Right.
What is the burden of proof that you as an employment attorney, a plaintiff's attorney, has to do?
Yeah, so preponderance of the evidence.
What is preponderance?
Basically, that just means that it's slightly more likely than not that the employer violated the law.
Like 51%?
Exactly.
Okay.
Yeah, so a friend of mine explained it at a trial with this analogy that I thought was really helpful.
You could have just said it. You could just be like, this is the analogy I use as a genius.
No, he came up with it.
Okay, I'll give him credit.
But he told the jury, you know, he said, if you have 2 cups of water and you put one more drop in my client's cup, that's preponderance of the evidence.
Ooh.
Right? So if they're equally full, if it's 51% that the employer violated the law, that's the burden for a plaintiff bringing any claim against the employer.
Okay.
And so I want to go back to your question about, you know, like if you're getting comments at work related to anything that seems discriminatory. So typically one isolated comment is usually not enough to have an argument that it's unlawful. I've had cases where like our client has been called like a really offensive racial slur. And according to the case law, that is not enough for it to be a hostile work environment.
Oh.
Yeah.
Okay.
Right.
That's terrible.
Exactly. So it's like, okay, so so the one comment of using the N-word or some other awful slur against somebody, that's okay then. I mean, that's essentially what the case law says. It doesn't say it's okay,
so
but
it
doesn't
has
say it's
to be
unlawful.
A pattern. Is that what they're saying? At least 2?
So probably not even 2, to be honest with you. So in order for a work environment to be unlawful and be hostile, as that term is defined legally, it has to be severe and pervasive are like the buzzwords that the case law uses. And that just basically means that it just has to happen a lot. It has to kind of affect the terms and conditions of your employment. like have an actual effect on you as a
Sure.
person. In order for us to be
Anything.
illegal.
Now,
Or,
I'm thinking
sometimes people don't know what to do and they engage in it too.
sure.
Because again, like that power dynamic.
Yeah.
So that does happen. Employers do use that to their advantage, and they do use it to try to discredit our clients, or argue that they weren't offended or that it didn't affect them, because it's like, well, why would you participate if you were so offended? It's like,
right.
There is this power dynamic sometimes. So I mean, the best thing I can say is, if that happens, I mean, we just make the best arguments that we can. If usually our client has a good explanation if they were participating in something, or it seems like they were. I mean, the answer probably is like, yeah, this is my boss. Like, what do you want me to do? I mean, I'm at work. I mean, this person's saying stuff to me. Like, am I supposed to constantly be battling them and telling them I'm offended? Like, it's very helpful if someone, and this is, I would recommend, like, if you have something happening like that at work, you should get an attorney's opinion on it. Because if someone calls us, well, first of all, like, one of the things that we do at our firm is we offer what's called a counseling session. It's like an hour of our hourly rate, and a person can meet with a lawyer at our firm for an hour and talk about anything they want. We can look at documents, we can give them advice as to how to handle something. And we created that because a lot of times, like, people can't afford to pay a full retainer, which I totally understand. I mean, attorney hourly rates are ridiculous, right? Like, I mean, they have to be, because, we go to law school and we have student loans and all that.
I mean, they don't have to be. Some people have flat fees. Yeah, like me. No, I get that. But you're actually supporting other employers. I'm just supporting myself and my 2 dogs, my 2 cats, my wife, and my teen.
Yeah.
But, it's enough. I pay my bills. I'm good. But you're right. I mean, someone who is scared of losing their job sometimes can't fork out all the money that they need to fully retain your services and take action. So to have that kind of flat rate, encapsulated hour, just to gather information and see if it's worth it, or see what you need to do next to make a case.
Exactly. That's exactly what we do during them too.
Yeah.
Like, we'll meet with people about anything they're going through at work, or if they have like a document that they want to know how to respond to, we review that, we tell them what to do. A lot of like our counseling sessions are really, here's what I'm experiencing, how do I report it, how do I handle it, how do I protect myself, or like, and even how do I protect myself in the future.
Right.
Like you were saying earlier, like, document everything, and make sure you get the employee handbook and report it the way you're supposed to. Those are all things that we talk about.
Because those are things that could be held against you if you didn't do them. Like, you skipped steps.
Correct.
And let's be clear, this is not Susan keeps stealing my sandwich in the fridge and I put my name on it.
Damn it, Susan.
Damn it, Susan.
Yeah.
This is something above and beyond, where it rises to the level of actually affecting your ability to exist as a human in your own skin.
Yeah.
While also providing competent work. What if someone is so affected by the toxicity of the environment and they're just kind of like holding it in, and then it affects their work and they get fired for poor work? Can they then turn around and say, well, normally I'm fine? This is a bar exam question, and if you say it depends,
no, that's
coming over this desk. No, I'm gonna say, like, if someone's in that situation when they're like, I'm not gonna report it because HR is golfing buddies with the manager, and I'll get fired, and they'll just say, you messed up with that forklift.
Yeah, for sure.
How do you kind of overcome those merited things?
I mean, first of all, that's very common. Like, most people are like, I don't trust my employer. Like, they're not going to do anything.
No, family business.
So, I mean, here's the thing. Typically, you have to report something in order to have protection under the law, because the idea behind that is, how is an employer supposed to fix or address something that it's not aware of?
Okay.
Right? So usually, like, a retaliation claim, like, those exist in employment law. And the way that a retaliation claim works is, like, if you complain about hostile treatment based on any type of protected status, that is what's called protected activity, meaning that you cannot be fired for it. I mean, you can be fired, but if you're fired, it's a violation of the law.
And so is retaliation if they, like, make your life miserable so that you want to quit?
So it depends.
Oh, no.
I've said that a lot, but it could be. Usually, though, it's more of like what we call an adverse job action. So like a demotion, or like reassignment to like a much less favorable position.
Yeah.
Reassignment to a bad location.
They're like, oh, you don't like this manager and the way they treat you? You're going to go work over here now.
Exactly. Yeah.
As opposed to moving the manager or correcting their behavior.
Yeah. Or, I mean, more often than not, it's a termination. Yeah. So, I mean, when you complain about something that you believe is unlawful, that is hypothetically supposed to protect you from retaliation.
Yeah.
And if you get fired, like, you may have a claim there.
Mm-hmm.
But I will say employers are usually careful about firing people that have engaged in protected activities. So,
Is that
as they
because
should
they're
be.
getting smarter or because they've been sued enough that
Probably both.
maybe? Okay,
I don't
yeah,
know.
that's fine.
Probably both.
We'll take fine.
I mean, I think most employers make a good effort to train their HR department and their managers, anybody in a decision-making position. I think they make an effort to train people on what to do, but, sometimes you just don't know what Bob is doing. Or,
Yeah.
and I don't mean Bob, I just mean anybody, right? Like,
Yeah.
you train people and you have good intentions and you tell them what they're supposed to do, but people screw up sometimes,
I mean, people are still people,
Exactly.
whether or not they're wearing your uniform.
Right.
But let's say you're out there and you're an ally or a person who owns a business who wants to make sure that they are inclusive as possible.
Mm-hmm.
What are some sort of tips that you would give them to make sure that as they're going through their business, whether they're starting it or looking at their existing work, how they can be more inclusive?
See, but I think you have to educate yourself on who is on the team, how do they work best, what's different and cool about them, what's unique about them. And then you really have to try to make an effort to shine a light on those things and appreciate those things and show people that you see them. I think that is the biggest component.
And there's a fine line between making someone feel welcome and pointing out their differences, which might create that otherness that they're trying to avoid. So I think in my experience, having a set written policy of inclusion and zero tolerance for harassment or anything like that. A scale, in my experience, 1 verbal warning, written warning, and then actionable consequences for offenders that give confidence to people, regardless of whether they're like, I'm pregnant, or, my surgery is coming up and I need to take time off, or, I'm going to start wearing, masculine aligning clothes or feminine aligning clothes.
Yeah.
They understand that if there is pushback, they do have a recourse. Definitely. And making that known, not just to the person who might be seeking the help, but the offender, that there are consequences. So in that way, kind of like you said, the education part of it, not only yourself, but also extending that to your people and communicating and then backing up with action that you are taking this seriously.
Yeah. And I was thinking about this when you were just saying that. I guess for me, it's really always more about just letting people be who they are. Like, they should come to work and feel comfortable to be themselves.
Yeah. Regardless
of what that looks like.
Yeah.
And as an employer, we have to support that.
Yeah.
Right. And I think it is much more of a action-based thing than it is. You can have those policies in place, and I totally agree with you. You have to have that stuff. You should have an employee handbook and an anti-discrimination policy. Absolutely. Yeah. Right. But that doesn't do any good if you don't actually abide by that. Mm-hmm. And I think a huge component of it is if you have someone that is treating somebody else badly, there has got to be a zero tolerance policy for that.
Yeah.
You cannot have that. And that's the hard part. As an employer, you cannot tolerate that stuff because that's what causes all these problems. Somebody makes a comment to somebody and it's discriminatory. It's you report it to the employer and they probably don't do much about it.
Yeah.
That is sending the message that that is tolerated. Mm-hmm. Right. And that can't happen. It can't be tolerated. It shouldn't be tolerated because you have a handbook and you have policies that say that you prohibit that stuff, but then you allow people to make 1 comment or 2 comments. It's okay, well, that is giving the green light for that behavior to continue.
Yeah.
And you're not sending a message that is not appropriate and it won't be tolerated in this workplace. That's what you need to do because, again, I think it's more just about, we need to just let people be who they are and celebrate who they are. We're all very different, and that's such a beautiful thing. But I think it's really more about people just want to go to work and enjoy their day as much as they can, not be singled out based on stuff like that, not be treated badly. And I think they want to know that if something like that does happen, that they have an employer that is going to stand behind them and do what's right.
Yeah.
And it's not that hard is the thing.
It's not, but it's just so litigated, unfortunately, in this capitalist, the society that we live in.
I totally agree. I honestly, like, a lot of these situations that I see in, like, cases I'm involved in, I'm just like, if the employer handled this the right way and, like, didn't protect this person who is the bad actor, like, we would not be here.
Mm-hmm.
Right? But, like, they don't do what they're supposed to do.
Or even the right thing. Or common sense. Or human decency.
Exactly.
If you are an employer where you don't know if something is going on because no one's told you, but you kind of wonder, is there such a thing as an anonymous survey? And would it be easier or better to, like, meet one-on-one with people and ask them, and would they even tell you the truth? Again.
Yeah, good question.
This is an answer she doesn't know how to answer because it's a huge hyperbole.
No,
but I'm going to give you a shot.
Yeah.
I feel like I'm setting you up for failure.
No, not at all. I mean, I think, so a lot of companies do have an anonymous reporting tip line or whatever. Much more common with larger employers for sure. But yeah, I mean, that's a great idea because you think about, it's like you put a complaint box in front of the manager's office. Like, nobody's going to put complaints in there.
No.
Right? Because the manager's going to see you. If you put it somewhere else where nobody knows, like, people will speak freely.
Yeah.
And that should be the case, right? You should encourage, like, people to tell you what's going on. So yes, I think the anonymous component is vital. A lot of smaller employers don't really have that.
Yeah. Because there's like 4 people.
Right. Like, you think about it, like, from perspective of our firm, we have 8 people.
Okay.
So it's like,
people are making fun of my beard. Oh, that's Jesse. He's the only one with a beard.
Exactly. Yeah. I think in that scenario, if you're a smaller employer and you don't have that anonymous option, like, you just definitely need to be someone that your people know they can come to.
Yeah.
And that is, they will know they can come to you if they have come to you before and you've reacted appropriately. And you've taken action based on whatever it is that they've told you and they feel heard by you.
That part.
Right.
That part.
You can't just say, oh, come to me. None of it matters unless you're actually going to do the right thing when someone comes and tells you there's a problem.
Okay.
Employers are always like, oh, we have these anti-discrimination policies. I'm like, yeah, so what? Yeah, that's fine.
Yeah.
Like, every employer should prohibit discrimination. Like, cool. You've got it written down. Like, that doesn't mean anything unless you actually put it in practice and you ensure that that is happening.
Yeah.
And that any type of discrimination is not tolerated.
So, anti-discrimination policy, good for you. Anti-discrimination practice, iconic. Good.
Very much so. Yeah, you need both.
Rachel, as we wrap up today, are there any kind of lingering thoughts that you want to put out there, either for someone who's in that situation or, someone who's branching out on their own in the community? Like, what are your perspectives as, like, employment law as a whole?
As an employee, I think it's super important you just educate yourself on your rights. What are my rights? I mean, we have even just our website. We write blogs on literally everything. You can find so much stuff on our website.
What is the address for that website, Rachel?
Well, guys, it's the FriedmannFirm.com.
Spell Friedman.
2 N's in Friedman. Friedmann.
Like fried man.
Like Friedman. Friedman.
Friedman Firm.
Exactly.
And you're Rachel Sabo Friedmann. Your husband, Pete Friedmann, is your law partner.
Yes.
And you offer 1-hour counseling sessions.
Yeah.
And if someone wanted to reach out to you, how would they do that?
The easiest way, probably just Google us. Just Google the Friedmann Firm and you'll find it.
Okay. And we'll have the link in the bio below.
Yeah. But I mean, truly, like, we have a search bar on the top of our site, and if you type in, like, literally any type of law, there'll be several blogs on it.
That you've written.
Yeah, that we've written. I mean, yeah, we try to write. The whole point of the website is, obviously it's great for Google, fine. But the point of the website is to really educate people, like, provide resources that they can look at for free that give you, it's not legal advice, guys, I have to say that, but it gives you an idea of what the law is and, like, what you can do to protect yourself. Like, we have all kinds of blogs about that stuff.
Yeah.
So,
well, Thank you for coming here and telling us and our listeners
Sure.
what they can do to protect themselves. Please do check out the Friedmann Firm online. And thank you for listening. I have been Hannah Botkin-Doty of Hannah's Legal Help, and you're listening to Legal Queries, Queer Legal Questions, Clear Legal Answers. Have a great day.